UK directors who try and phoenix their companies without professional guidance always make mistakes. Now, if you don't understand the rules around buying back company assets, you risk disqualification and being chased personally for company debts. What might look like a fresh start can quickly turn into a nightmare. You can buy back your company assets either pre-insolvency or post-insolvency, but you've got to follow strict rules. Now, this year there's been about 28,000 UK companies that have entered insolvency, and many of the directors will have bought back their business assets legally. I want to warn you about an inquiry I had earlier this year. Now, this guy owned a manufacturing business and he rang me up and he said, Chris, I basically want to buy the assets back of the business. And I had to dig into it. I said, well, tell me what else is going on. And there was also some quite valuable contracts that he didn't really want to tell me at the start. And I said, listen, you need to have an independent valuation done on everything. The fixed assets, the intangible assets, the website, the phone number, the work in progress, the contracts. But he ignored me because he'd spoke to somebody else who said he could do it a different way. And he did it his own way. He just thought that he could move assets out of a business sideways and goodwill for little money. Guess what? The insolvency practitioner that he worked with has accused him of undervaluing the assets, and now they're being chased for £75,000. Now, when a company goes into insolvency, could be liquidation or administration, the assets then move over to the insolvency practitioner, and they are duty bound to sell those assets for the best possible price to repay creditors, or if the assets have been sold before they get appointed, they've got to investigate whether or not you sold those assets for a fair market value, okay? So if you're a UK director and you're thinking that you want to buy the assets of your insolvent company, and let's say you're going down the liquidation route, well, you can do, but there's some things that you've got to follow. When you're deciding to buy your assets back, so let's say you are looking at insolvency, you have some assets in the business and you want to sell those assets before you appoint the insolvency practitioner, okay? There are things you must do because it's going to get scrutinised. The first thing is you need to have a valuation done on this business. And the valuation needs to be from a credible agent, and they will value everything. Your plant, your machinery, your fixtures and fittings, your website, your phone number, your database, your intangible assets like goodwill. Is there any work in progress? Does the business have any contracts? And also you want to document the process in writing, okay? So if you're going to be buying your assets, say pre-insolvency, make sure you speak to the insolvency practitioner you're going to consider using, and make sure that you are communicating between you and the agent. So if you're making an offer for those assets, you do it in writing, and what you're hoping for is the agent will write a letter of recommendation saying those assets are being sold for what they think is a fair market value. Once you get your valuation done from an agent, there'll be a fairly detailed report and it'll go into the details of the assets. There'll be a little bit of history about the business, but there's generally two figures, and there's an in situ figure and there's an ex situ figure. And what those two figures means is the agent believes ex situ, so if the agent has to come and take those assets from your premises and sell them at auction, he believes he will get that figure. And the in situ figure is what the agent believes they're worth to you if you buy them back and essentially start the business again in a new limited company. Your offer to buy those assets needs to be close to the in situ figure. And the closer you can get to the in situ figure, the more like, well, if you buy it for what the in situ figure is, it's very hard for an insolvency practitioner to criticise you. And remember, the insolvency practitioner is going to look at this stuff. You've also got to pay a fair market value, which is the point really I've just covered. And if you're going to do deals before an insolvency practitioner is appointed, you need to make sure that you're paying fair market value, but also speak to the insolvency practitioner that you're about to appoint. You know what? If you're thinking of selling your company assets before you before you appoint an insolvency practitioner, it's that important you have to do it right. What my suggestion is go to the description. There's a link at the top. Click that link. One of my team will call you today and give you some free and independent advice about how to do this properly. Now, I believe there are a number of steps when it comes to buying back company assets, okay? Now, the first step is you speak to the insolvency practitioner about what you're planning on doing. Some insolvency practitioners will want you to buy the assets from them once they've become appointed, okay? Now, if you are looking at buying these assets, selling your old company, your insolvent company is looking at selling these assets before you appoint that insolvency practitioner, you want to speak to that insolvency practitioner and tell them what you're planning on doing, okay? And you must make sure that you pay a fair market value for those assets, because if you sell them before the insolvency practitioner gets appointed, they're going to scrutinise that sale, and if there's any hint that you've sold those assets for less than market value, the insolvency practitioner could make you liable for the difference, or essentially rewind the deal and bring the assets back into the insolvency estate. Now, step 2 is get an independent valuation done, okay? Hire an agent who is used to these scenarios. We can make recommendations for you. And this report will protect you, because insolvency practitioners, they are legally required to check that any sale of assets has been done for a fair market value, especially if it's to a connected party, okay? And what that does, it means that you can't lowball buying your assets. Now, the reason you get an independent agent is your agent will write what they believe these assets are worth. Step 3, what you're going to do, you're going to submit a formal offer to the agent. You will put your offer in writing, usually via email, and you will say the details of the assets that you want to buy, the amount that you are offering, hopefully aligned with the in situ figure on the valuation, and how you intend to fund that purchase, okay? Now, you've got to be professional in this email. It's going to be seriously scrutinised by the agent and also by the insolvency practitioner. Now, if you are looking for some terms to buy that asset over, so you might be offering 15 grand for the assets, you're going to put 5 grand down, but you want the other 10 grand over a period of 6 months. Well, you need to make sure that the insolvency practitioner who you're about to appoint would accept those terms. In some cases, the insolvency practitioner is going to want things paid quicker, but I believe in most scenarios you can get some terms, but you've got to have them agreed in principle by the insolvency practitioner. And step 5 is once that's done, once the offer's been accepted from the agent, what you can do is you will raise an invoice from your insolvent company to your new company that you've set up, and it's sold on an invoice basis. And then what happens is the new company has legally bought the assets from the insolvent company, and you can start trading again. Now, there's something you've got to be really, really careful when you're doing this, and it's using a same or similar name. Because if you liquidate a business, there's a thing called Section 216 of the Insolvency Act. You cannot use the same name or a similar name for a period of 5 years. And the law's there, and it's there to prevent confusion with the old company and the new company. Now, there are a number of legal routes that you can go down to essentially reuse the name, and they're called Section 216 exemptions. But here they are, and you've got to be dead careful. So the first time where you would be exempt from Section 216, let's say there's Worden tyres, okay? and that's the insolvent business. But I've had Chris Worden Tyres Northwest trading, and the key word here is trading, for over 12 months. Well, that scenario means you're exempt from 216 because I already have a similar name that's been trading over 12 months. Another scenario is you can then apply to court and basically tell a judge why you should be exempt from 216. I think this scenario is quite expensive. You could be in £5,000 to £10,000 worth of legal costs, and the judge still might not agree with you. So I think for most directors watching this is the route I will go down if you want to use the same or similar name. And it's buying the name from the insolvency practitioner. Okay? Now remember when we said about getting the report done, the agent's report, the valuation, there'll be a section in there for goodwill. And the goodwill will encompass the brand name, the trading style. Now let's say that your goodwill is £1,000. What you will do is, on the day of liquidation, you will transfer the insolvency practitioner an additional £1,000 plus VAT for the brand, trading style and trading name. And then you will need to do an advertisement in something called the London Gazette or the Edinburgh Gazette if you're north of Hadrian's Wall. And then your duty is to write to the creditors of the company to tell them what has happened. And out of the three scenarios, if you've not already got a company that's set up with the same or similar name, I would always go down the route of buying it back from the liquidator. Now, I want to talk about some common mistakes, okay? One of the mistakes that sort of flies in the face of what I said is selling your assets out of the insolvent company before you appoint the insolvency practitioner, because that can be criticised, especially if you do it with no valuation, okay? So remember, if you're going to sell assets before you appoint an insolvency practitioner, you must have it backed up with a valuation. You must have an agent recommending your sale. Another big mistake is underpaying for those assets, okay? Now, directors, I've heard all sorts of stuff. Nothing shocks me anymore, right? I've had directors move assets out of the business because they didn't think anyone would check them. There was no record of them. I've had people say to me on the phone, let's say they've got a vehicle, and the vehicle, even on WeBuyAnyVan.com, is worth 15 grand. And they say, Chris, why don't I take the engine out? You can't do that. An insolvency practitioner has a legal duty to ensure that best value has been paid for those assets. And if they discover that you've underpaid, it's a transaction under value, they can void the sale and take back the ownership of the assets to sell at public auction, or they can make you personally liable for the shortfall. And that type of behaviour, if you try and underpay for assets, it will be reported in your director's conduct report. You could face disqualification, okay? Another big mistake is ignoring company name rules, okay? So if you are trading in your new company with a same or similar name without permission, okay, and it's breached section 216, the consequences of that are massive. You could have a huge fine. In the worst case scenarios, you could be imprisoned. You could be made, you know, the debts that you've got rid of in the insolvent company, if you're seen to be breaching section 216, those debts could then get attached to the new company. Another big mistake I see is people just thinking, I'm not going to get professional help here. I'm going to handle it quietly. I know, you know Dave down the pub, Dave the D head, yeah? They're going to get advised off Dave down the pub. Please stay away from him. He's dangerous. In these scenarios, you've got to be transparent, doing all the things that I've just said. And most directors who do this, they don't get punished for buying back their assets. They get punished for doing stuff wrong, because in many scenarios, right, the director's offer to buy the assets back will be the highest offer. Now, let's say you've got assets in the business where there are vehicles, there's plant and machinery, and there is buildings perhaps in the business. Well, the insolvency practitioner may insist that they want to sell those assets once they become appointed, okay? And remember, even in that scenario, you can still buy your assets back, but you must make a fair market value offer. The insolvency practitioner is duty bound to get the most money in for those assets in the hope of paying back some creditors. Now, there are a lot of benefits of doing this properly, okay? If you do it properly and you sell your assets to a new co, potentially you could save save jobs. Potentially you can save customer relationships. It'll retain key assets and equipment that will allow, well, it'll give your new company the best possible chance. And obviously in a pre-pack, you get a clean slate because the legacy unsecured debts gets written off. And I think if you do this right, it demonstrates integrity, okay? Now, how do you buy company assets back in insolvency? So you can do it pre-appointment, but you must get a valuation done. You must submit a fair offer. You've got to do this transparently. If the insolvency practitioner is going to, basically their role is going to sell the assets once appointed, you will approach that insolvency practitioner. They will also want an independent valuation. You will submit an offer to that insolvency practitioner and they will review whether it's a fair offer or not. When you're buying assets, a lot of the time, you'll be able to pay for those assets over a period of time. Again, that's up to the discretion of the insolvency practitioner. This is not about hiding. It's about handling it right, and transparency is your best protection. So, if you want to find out more about pre-packs, what I want you to do is go to that video there. That video will tell you everything about a pre-pack administration and a pre-pack liquidation. It'll go into more detail about asset sales, and it'll be a great video for you to watch. Thank you for your time, Chris Worden.